We've got Abhishek Rastogi, the petitioners advocate, who's with us here on the line as well. Thank you very much, Mr. Rastogi, for joining us. If you can just take us through, this important judgment that has come out from the top court in terms of how this is now going to have implications on any recommendations made by the GST Council.
This is a remarkable decision and will completely change the landscape of the GST taxation here in India. The GST Council has been giving a lot of recommendations, but today the question which was there before the court was not only on the constitutional validity of these recommendations, but also what role GST Council must play. So I think from the perspective of the benefit which will come to the Indian importers, it is huge and immense. I was arguing this petition for several petitioners all across the country, and we welcome the decision. We are very happy with the outcome of the decision. This is the victory of the Constitution of India, because today the taxpayers are in a very comfortable zone reading this decision, because if something is unconstitutional, the courts strike it down. It is not only the matter of money, but also the matter of principles. So from that perspective, it's a brilliant decision. It will help entire industry, and entire industry was waiting with a bated breath for this decision.
Right.
As far as the implications are concerned, all the money which has been paid now becomes eligible for refund. The importers can file refund claims and can start getting the money. Petitioners in Gujarat had already filed refund claims, and they had started getting money after our order from the Gujarat High Court. But now all throughout the country, this is applicable all throughout the country now, and all importers situated in any part of the country can today file the refund and claim their money back after the Supreme Court decision.
Right. So, Mr. Rastogi, what quantum of amount are we talking about that is eligible at this point in time? If you can give us any estimation of that. And this is one aspect of this. Now, what is going to be the next steps? Because, like you said, the entire landscape of the taxation itself will change. The role of the GST Council, a lot of things will have to be overhauled now.
No, actually, see, as far as the quantum is concerned, it is very difficult to estimate, but this is not less amount for any person who is having significant imports. So any importer in the country will have the benefit. In few cases, this tax is a pass-through. It doesn't burn the fingers of the importers, but in some cases, for say for oil companies, it becomes a straight cost, and that cost is huge, keeping the larger picture in mind. So from that perspective, this is a great decision from the cost-saving perspective. As far as the implications otherwise are concerned, everybody will now be eligible for refund.
And going forward then, how do you see the entire GST Council? Any recommendations? Obviously, the GST Council meets that we keep seeing happen, and the changes that get announced in those meets, which usually become implementable almost immediately.
See, I think the Supreme Court is very clear. The Supreme Court has gone to the provisions of the Constitution of India, which were amended in 101st Constitution Amendment Act. The Supreme Court today very clearly says that GST Council has a recommendatory role. The GST Council must recommend to the Parliament and to the state legislatures. After that recommendation, it is up to them how to decide on the issue, how to make those changes, what amendments in the statute are essential and required, and so on and so forth. So from the perspective of the recommendation, keeping the Constitution of India in mind, the court is very clear that the recommendations of the GST Council will have only persuasive value, which means that going forward, if the recommendation of the GST Council are incorrect as far as the constitutional validity is concerned for a provision, the provision will be subject to judicial review, which means that basis the recommendation of the GST Council, if any amendment has happened or any statutory provision has been enacted, that will be subject to judicial review, and the courts will decide those issues pragmatically.
Also, Mr. Rastogi, for our viewers, if you can just give us a little bit of the background into the petition itself, the reason why this petition was filed in the first place, the trigger at this point.
I had filed this petition way back in 2017. We have also filed the petition for the service tax applicability on ocean freight. The issue is like this. The exporter outside of India export goods to an importer in India. The element of freight is not paid by the Indian importer, but is paid by the exporter outside of India who is exporting those goods into India. So the question is that the ocean freight, which is paid by the exporter outside of India, should the tax on that ocean freight be made applicable to the hands of the Indian importer? And we had challenged the validity of this levy on the Indian importer on a reason that Indian importer is not the service recipient. He is not receiving the services. The services are being received by the foreign exporter. He pays for that service of ocean freight, and the service provider is also outside of India. So when the service provider is outside of India, the service recipient, who is the foreign exporter, is also outside of India. Why should an Indian importer bear the brunt of tax on ocean freight? That was the moot point of concern.
All right, Abhishek Rastogi, thank you so much for joining us and giving us all of that perspective. This is